as plainly as it could be, the prohibition on publication of information until there's a final judgment is a prior restraint. And coming with that is a burden that is insurmountable.
All rise. The Judicial District Court, Department 13 is now in session. The Honorable Mark Denton presiding.
Good morning, please be seated. Okay, let's call the case of Nevada Association of Public Safety Officers versus Las Vegas Review Journal. Please state appearances of counsel, identify parties and party representatives who are present today.
Morning, Your Honor. William Schuller on behalf of NAPSO and its members.
Good morning, Your Honor. Wade Gochnour on behalf of the City of Henderson.
Morning, Your Honor. Joel Tasca on behalf of the Review Journal, and Matthew Cate on the Review Journal behalf as well.
All right, it's on counter today on defendant's motion for a preliminary injunction. I see upcoming on November 16th is defendant's motion to associate counsel. Any objection to the advancing the hearing of that to today?
No objection.
The city has no objection, Your Honor.
I don't believe there's any opposition to that motion, correct?
That's correct.
All right, cause of hearing. There being no opposition, I'm advancing the hearing of that motion to today, and it's granted. Please submit proposed order. We need to set a status check. 45 days.
45 days, that would be November 27th at 9 a.m.
November 27th at 9 a.m. That's to show that the state bar has been notified of the Mohawk Beach admission. If the record reflects that, at that time, we don't need to appear for the status check. All you need to do is send notice of entry of that order to the state bar. Okay, do that by mail because you're not registered for registered service. Okay?
Thank you, Your Honor.
Okay, so now I'll hear argument on the motion for preliminary injunction.
Thank you, Your Honor. The last hearing, I believe you indicated that today's focus would be on likelihood of success on the merits.
Together with the reparability of injury.
Sure. In regard to likelihood of success, what we need to do obviously is interpret NRS 289.025. Again, as we discussed last time, the Conrad decision held that that statute is unambiguous. If the court agrees and looks at the plain language of the statute, there's no limit on the scope of the protection for the officers' photographs and home addresses under that statute. And also in the Conrad decision, they held that in addition to photographs, video is afforded protection under subsection 1. I don't think there's any dispute between the parties that none of the exceptions in the statute apply, and therefore under a plain reading of an unambiguous statute that has no limiting language regarding who must abide by its confidential protections, I think it's clear that NAPSO ultimately prevails here. However, even if the court determines that there is some ambiguity in the statute, the Review Journal's interpretation of the statute is still incorrect. In my reply brief, I gave at least 10 examples in NRS Chapter 289, whereby the legislature utilized specific language saying the law enforcement agency shall not do X, Y, or Z. Repeatedly use that language throughout NRS Chapter 289. That language is conspicuously absent in our statute. I also cited to the Nickmeyer opinion, which held that those differences, specifically those differences in our NRS Chapter 289, cannot be ignored, that there's a reason for those differences, and that they have to be given accord depending on which statute you're looking at. Also, the RJ's interpretation of the statute would essentially defeat the purpose and public policy underlying the statute. The statute's goal is to protect the private information of public officers. If anybody could publish this information other than a law enforcement agency itself, the protections would be essentially nugatory. And again, courts must avoid interpretations resulting in such absurd results. Just briefly, as to associational standing, I think I addressed it adequately in my reply brief, but we didn't name the officers for the same reason that we're here, to protect their confidential private information. If need be, those officers are willing to participate in this action. We would only ask that rather than being named directly, we name them in some confidential manner, officer number 1, number 2, for example. I would argue, however, that the officers aren't even needed in this particular action because this is an action requesting only declaratory relief regarding statutory interpretation. I don't know what benefit naming the officers individually could possibly have. Really, I don't see the need for discovery in this matter regarding the declaratory relief claim. Touching basically, briefly on probability of irreparable harm, we don't need to show a threat or that somebody acted on the threat of physical harm to an officer to establish irreparable harm. That would be one way we could do it. And again, each time the video and or photographs are published in another article, the chances of that happening increase. And as I said during the last hearing, I predicted that the video and or photographs would be published in an article reporting on the last hearing. That in fact happened. So now we have 3 articles out there that include the video and photographs of these officers. And after today, we'll probably have a 4th article. However, it's the violation of the statute itself that's already constituted irreparable harm. Once the RJ took it upon themselves to publish this video and photographs, the confidentiality of the officer's private information was breached and irreparable harm was established at that point in time. They've had to deal with knowing that their identities are out there since that time. As to hardship to the parties, there's almost no hardship whatsoever to the RJ, given that after we filed our complaint and application, the City of Henderson provided them with a redacted version of the video, which they've chosen not to substitute for the unredacted version. So not only do they not have to make any changes themselves, all they have to do is substitute a redacted video for an unredacted video. Almost no hardship whatsoever. And again, the photographs are essentially still shot from that video. So by the same token, it would almost be no hardship. Public interest. Obviously, the public interest always has a valid interest in the safety of its local officers. And in enacting NRS 289.025, the legislature made a determination that this information, in fact, is not public. That's the plain language in the statute. Moving on to their First Amendment arguments, more specifically that any ruling requiring a change to the video would constitute a prior restraint. That argument fails on at least 3 fronts. First, this is a content-neutral law, and content-neutral laws are not a prior restraint, provided there is some significant, substantial governmental interest underlying the regulation. And again, here, just as there's a public interest in officer safety, there is a governmental interest that is substantial and significant in providing for the safety of its officers. Even if the court found that this was not a content-neutral statute, which I don't know how you could say otherwise, but in that case, it's low-value speech. I cited to numerous cases regarding different categories of low-value speech, which are afforded less protection under the First Amendment, one of which is the non-newsworthy disclosure of private facts, such as home addresses of public officers. One fact of which our statute seeks to protect. The third reason that it's not a prior restraint is that we're dealing with a non-public forum here, the Henderson Henderson Detention Center. I would alert the court that it need look no further than regulations regarding our courtroom and this particular building to show why a non-public forum is not as accessible to the press. First, we have, in this very case, the Review Journal filing a media request allowing it to record in the courtroom. In doing so, the requester has to certify that they'll comply with Supreme Court Rules 229 to 246 inclusive. Rule 230, Supreme Court Rule 230 that is, requires a duty on news reporters to obtain permission before they can record within the courtroom. More recently, on July 21st, 2023, the 8th Judicial District Court issued Administrative Order 2304. Now, pursuant to that order, not only are the interior of the courtrooms afforded extra protection and require permission prior to recording, but the courthouse as a whole now does. In that order, Judge Weiss noted that there were recent complaints by jurors and court personnel that precipitated a review of the use of electronic devices, including photographs, recording, and filming, the public visiting the courthouse and courthouse employees performing their duties. The similarity in that language is telling, given that our statute deals with the photographs of officers performing their duties. In that administrative order, it states that courthouses are non-public forums, and our court, the courthouse includes courtrooms and court employees themselves, and that the courthouses may have reasonable and viewpoint neutral restrictions on photographing, recording, and filming. And again, just as the courthouse is a non-public forum, any jail, including the Henderson Detention Center, is a non-public forum. And I would alert the court to 9th Circuit, United States v. Douglas, 579 Federal 2nd, 545, citing Supreme Court case Adderley v. Florida, 385 U.S. 39, which expressly holds that jails are non-public forums. So again, whether the statute is ambiguous or unambiguous, it's clear that the scope of protection that it affords public officers, all officers, whether they be patrol officers, corrections officers, vice, non-vice, doesn't matter. The scope of that statute is all-encompassing. It's not limited to a law enforcement agency itself. If it was, it would state that, just as the other statutes under NRS Chapter 289 do. So with that, I'll reserve further argument. Unless Your Honor has any questions.
Mr. Gochnour?
Yes, Your Honor. I just have 3 points I'd like to make. First, which we made in our brief supporting NAPSO's motion for preliminary injunction. In terms of irreparable harm here, we have to remember that Chapter 289 is in fact the officer's Bill of Rights. These are rights that are granted to police officers. They have violated that right, and the only way to recover that right is through this. Money damages are not going to get their anonymity back. The only way to stop the continued failure of their ability to keep their anonymity without their consent is through the injunction process, Your Honor. So that's first and foremost. Secondarily, with regard to associational status, I do want to remind the court that in June of this year, the United States Supreme Court granted what I like to refer to as the Harvard admissions case. And that case was brought by an association on behalf of Asian students who had applied to Harvard but not been accepted. And the Supreme Court went through the very same test that was cited in plaintiff's brief to Your Honor on Friday, which is the Apple Valley case, or the Washington versus the Apple Growers Association, I can't remember. There's a 3-part test, all of which are met here, Your Honor. It's that they could do it, but the association is bringing it on their behalf. They have a similar interests, and they're going to be an adequate representation. All those are met here, Your Honor. So to the extent that they're trying to say there's no standing, that's without basis. The final point I would make, Your Honor, again, was what I made in my brief. The RJ's brief contains a lot of argument about prior restraint, about how NAPSO's seeking to punish or require them to change their reporting. That is not what we're talking about here, Your Honor. In fact, the only thing we're asking to do is take the exact materials you have, put a blur on the face, just on the face of the officers. That's all that's required here. Whether they can do it from their own video, which is a package, and they know how to blur, because as pointed out previously, they blurred a swastika tattoo off one of the inmates. So it's certainly not that difficult for them to do. They can make that correction. And I did point out, again, despite their assertions that the Supreme Court has never found that anything could ever stop their right, there's several Supreme Court cases, Your Honor, that say First Amendment does not invalidate every incidental burdening of the press. The Supreme Court also holds that the press is not entitled to any additional entry into public records that's not available to the general public. Again, these are not records that would have been available to the general public, but for compliance with the statute. And by the same token, on this general statute, they're required to comply with that. And I think that's shown, Your Honor, by the Dahlberg case that we cited to Dahlstrom versus Sun Times Media. That's the case out of Chicago where a paper had published some private information under an act. And the court in that case said, no, you should not have done that. For whatever reason, the plaintiffs didn't apply for an injunction, although they had that cause of action. The court noted in that case, the U.S. District Court for the Northern District of Illinois noted that it would have allowed an injunction, that prior restraint would not have prevented the injunction. And that case was upheld by the 7th Circuit Court of Appeals, citing repeated United States Supreme Court authority, Your Honor. So to the extent that they're arguing that somehow we are infringing upon their rights as a newspaper, it's just simply not the case. They still have the exact same story. They still have the same supporting materials. They can tell their story however they want. It's just that the only thing that is not really of public interest is what is the face of the officer, which they can blur, Your Honor. So with that, I submit.
All right, thank you. Scott?
Thank you, Your Honor. Again, Matthew Cate for the Review Journal. And I neglected to mention that we again have representatives of the paper here today, in-house counsel, Mr. Littman, Glenn Cook, the executive editor, and other representatives as well. I think it's important to clarify for today's proceeding, which is a preliminary injunction, the court is being asked to issue an order before final judgment in this case that would prohibit us, the Review Journal, from publishing information tomorrow and the next day, all the way through final judgment. That is a prior restraint on its face, as plainly as it could be. The prohibition on publication of information until there's a final judgment is a prior restraint. And coming with that is a burden that is insurmountable, essentially. In all cases that have come to the Supreme Court of the United States and the Nevada Supreme Court, not once has one been affirmed against the press. And the court has to ask itself today in this proceeding, separate from the injunctive relief analysis, separate from the merits determination, separate from the hardships of the parties, although all these things are implicated. There's a lot of the overlap here of the issues. But separately, the court has to ask itself, has NAPSO and the city, has the moving party NAPSO provided the court sufficient information to convince the court that this case is going to be the first prior restraint against the press to be affirmed by the Nevada Supreme Court and the U.S. Supreme Court. And as our papers have shown, and as we argued last time we were here, the interests have never been found to be sufficient to warrant a prior restraint against the press. When you have national security interests arising from the potential publication of the Pentagon Papers, the Supreme Court of the United States said a prior restraint cannot issue to prohibit that publication. When you had in Oklahoma the publishing company versus district court
You had a court that sought to enjoin the publication of a minor's name. The minor had a statutory right of confidentiality because he was involved in juvenile proceedings. And the Supreme Court of the United States said that weighty interest that the minor has in statutory confidentiality cannot justify a prior restraint. In the Nevada Supreme Court case involving the Review Journal 5 years ago, we had a very analogous situation where you had a prior publication of autopsy reports. You had a grieving widow of a slain police officer in a mass shooting who asked the court, before we get to the ultimate determination of my privacy claim, grieving widow saying the publication of this autopsy report violates my privacy rights and the privacy rights of my family. But before you get to those merits, Your Honor, issue this injunction, prohibit the Review Journal from publishing that information any further. And the district court, another department of this court, agreed with the widow and said, these privacy interests are weighty indeed, and we are going to enjoin the Review Journal from publishing that information. And also another argument that was made that the trial court found compelling was that the Review Journal didn't satisfy the plaintiffs and the court's concerns about the news value of the autopsy reports. The district court asked the Review Journal to justify its publication of the autopsy reports, which were redacted in certain forms as a result of the release from a public records request. So the court said, newspaper, justify the news value of your publication, and I have serious weighty interest here. I'm going to restrain you from publishing until this case is settled and resolved. And the Nevada Supreme Court said that was error. They reversed that prior restraint and said, we acknowledge for the purposes of this prior restraint analysis, we acknowledge that the widow may have privacy interests here that she can prevail on at the ultimate merits of this case. But under mandatory Supreme Court precedent, the weighty interest, it has to be far higher than even that. It has to be higher than national security issues. You have to have imminent danger to a compelling state interest of the highest order. And in those cases that we've cited, you had very serious and largely undisputed interests at stake, and they weren't sufficient to affirm and allow the prior restraint. This case, what we have here, is an assertion that the Review Journal violated the peace officer's rights to veto publication of images. NAPSO and the city argue about this being a confidentiality statute and that these officers have a right of anonymity such that they can take the extraordinary step of participating in this case anonymously, to which we object. That situation requires further briefing and a motion. But anyway, they're arguing that this case implicates those types of confidentiality interests, but these officers are in the public every day. They work in a public building. NAPSO has conceded that they're not undercover. They're working with inmates every day. As we heard last time, their neighbors know who they are and what they do. These officers' identities are not confidential. This statute is about the disclosure of their images in the context of the Peace Officer Bill of Rights. And that's the interests that are at stake. And this alleged violation is not anywhere near the circumstances that were at issue in the Panama Papers case, which did not justify prior restraint. And so I don't see, and we submit that there's not a justification here. Now, in response to the prior restraint arguments, NAPSO and the city bring in other First Amendment issues that are merits-based. They're based on the application of the statute. That are based on whether Dahlstrom, which is distinguishable important reasons that I hope to get to, Dahlstrom and these other cases show, and the fact that sometimes you can find people liable for libel or obscenity, which is really no longer the case, but the fact that some speech is not protected, those are merits-based questions. NAPSO and the city have not provided the court a single case. None of those cases, those dozens of cases that they cited in their First Amendment discussion, had to do with the prior restraint. GLAD, which was a disability rights case brought in the Ninth Circuit against CNN, they do reference this case as being a prior restraint case. That case involved a disability rights group suing CNN over a California statute that purported to require closed captioning to be posted on videos that CNN and others post online. That case in the Ninth Circuit considered whether the statute was content neutral, considered the question of whether the statute itself would constitute a prior restraint, but importantly, for today's proceedings, it's important to appreciate that GLAD, that case, was not a preliminary injunction case. That case was not being heard on a preliminary injunction motion. That was a merits determination for an anti-SLAPP motion. And the court, said that we're imposing a prior restraint on you in this case. We're holding that in the future, this statute requires you to add some additional information. It doesn't affect your presentation of the news in the way you want. And so it's distinguishable for those two important reasons, in addition to, of course, not being binding on this court. And to be clear, they also argue about the low value of this imagery here that the Review Journal wants to publish. There's no low value case in the prior restraint context where the Supreme Court, or the Nevada Supreme Court said, we agree that this is low value, we can restrain you until an ultimate merits decision. Again, that was the same argument advanced by the widow in the Review Journal case 5 years ago. These autopsy reports aren't newsworthy enough to justify the publication. You can restrain them. And the Supreme Court of Nevada said, no, that's incorrect. That's putting the burden on us. In the prior restraint context, the burden is on the moving party to show the harm that would befall them absent the prior restraint. It is not on the newspaper or the person seeking to be restrained to justify their speech. That's a merits determination. And I'll avoid getting into the merits determination at this stage because the prior restraint point is separate and compelling. And over and again, these prior restraints, these efforts have been rejected by the High Court of Nevada and the United States when there's not been a showing of imminent danger, of serious risk of harm. And NAPSO doesn't have that showing in this case. The alleged violation, assuming the court were to find one at the end of this case, is insufficient. And for that reason alone, the motion for preliminary injunction should be and can be denied without even considering these other issues, which I'll now turn to. On the statutory argument, well, first I'll start with the harm. I've already addressed the harm to some degree and the lack thereof, and that it's basically at this point an argument about statutory violation. They've not cited any cases from Nevada that actually hold that a violation of a statutory right is irreparable harm. The cases they cite are from Oklahoma and Pennsylvania involving government actions or actions against the government and whether a violation of a statute gives standing to sue the government or for the government to sue. But again, the question here is whether there's a violation of 289.025 and the harm is that alleged violation. But I'll get to this, why the statute doesn't apply, but importantly, I think the court needs to keep in mind that to prove a violation, NAPSO has to identify the officers who did not consent. Lack of consent to dissemination is a requirement to prove a violation of 289.025. That's in the statute. So even if there were standing, even if the statute applied to the Review Journal, even if they could overcome the merits First Amendment analysis, to prove a violation of 289.025, NAPSO has to show these officers didn't consent. So NAPSO said there's no dispute over that the exception that there's no consent and that these officers weren't arrested. We dispute that until we see evidence that these officers did not consent and that they were not arrested. We can make assumptions, and that's what NAPSO is essentially asking the court to do, because it's not provided evidence of lack of consent and lack of arrest. So for that, there's no violation, even if you go down the rest of the decision tree. But to start back at the beginning, this statute in the Peace Officer Bill of Rights only applies to employers. The Nevada Supreme Court has 3 times interpreted the Peace Officer Bill of Rights to hold that it applies to employers and the specific types of employers identified in the statute. Nickmeyer case that NAPSO cited in its brief and referenced earlier today. In Nickmeyer, a marshal of this court sued the court, the 8th Judicial District, arguing that it owed him rights and violated his Peace Officer Bill of Rights rights. And the Supreme Court of Nevada was asked whether this court constitutes an employer for the statute that marshal invoked. And the Supreme Court of Nevada said this court is not an employer under that provision of the law. In Ruiz, the Supreme Court again explained, this was predated Nickmeyer. Ruiz, the Supreme Court of Nevada explained that the Peace Officer Bill of Rights governs the responsibilities and rights between the peace officers and the agencies that employ them. And finally, most importantly, and in a case that NAPSO hides from, Bish versus Las Vegas Metropolitan Police Department, you had a police officer who sued the police department and her union. And she said the union violated her rights in the Peace Officer Bill of Rights by not sufficiently participating in an internal investigation on her behalf. She said, this statutory framework applies to my union. The Nevada Supreme Court said, no, it does not. They said, you look at the framework of Chapter 289 in the Peace Officer Bill of Rights, that applies to employers. It emphasized that word just the way I do now, and it did so because it said, look at the right of relief statute in the Peace Officer Bill of Rights. That's NRS 289.120, another authority that is directly binding and compelling in this case that NAPSO ignores. The review statute, the right of relief statute says that a police officer who is aggrieved by a violation of the Peace Officer Bill of Rights can sue. Who can he sue or she sue? His employer or her employer who violates the law. What can they do when they sue? They can ask the court to enter an injunction against whom? The employer who violates the Peace Officer Bill of Rights. And that court, its jurisdiction is constrained to issue an order enjoining the employer from further violations. That word employer is in that statute 3 times. No other entity can be sued in that right of relief statute. NAPSO doesn't address it, the city doesn't address it. It's there, plain as day, and the Nevada Supreme Court said when you look at that statute, when you look at the Peace Officer Bill of Rights, it's clear that the police union can't be held to the Peace Officer Bill of Rights. The same result has to apply here to the newspaper, who doesn't employ any officers, who doesn't represent them in a representational associational capacity. There's no application of that statute to this case. And even if it were read to somehow apply, now the First Amendment merits arguments come into play. This is where we talk about the Dahlstrom case that counsel for the city mentioned out of the Seventh Circuit. We talk about Bartnicki, the Daily Mail, these other cases that say when you have a statute, when you have a common law right that would purport to impose punishment, or as the Supreme Court of Nevada said, injunctive relief against a publisher of information, you can't apply that statute in that manner when the person who publishes the information received it without engaging in any unlawful conduct on its own. That's Bartnicki. To be clear, Bartnicki involved an illegal recording of a phone conversation by a third party who shared it with another person, who then disseminated it to the press. The people whose recordings were, people who were involved in the call that was recorded sued the intermediary and sued the press. And the Supreme Court said that's a content-neutral statute. The wiretapping statutes are content-neutral. And this is, again, the merits analysis. The wiretapping statutes are content-neutral, and they clearly prohibit the illegal recording of the phone calls, and they clearly prohibit the dissemination. But you can't apply that statute to the intermediary or to the press because they didn't affirmatively break the law in obtaining that information. That's Bartnicki. Dahlstrom, that the city cites out of the Seventh Circuit, is a negative application of that same principle. In Dahlstrom, the city neglects to inform the court. The reporter, it was undisputed that the reporter obtained the information affirmatively themselves in violation of the statute. And the reporter then published the information. So there was no intermediary, there was no third party acting unlawfully. The reporter went and grabbed the information themselves in violation of the statute. So Dahlstrom is an application of Bartnicki, just in the reverse, the negative application. So we have Bartnicki here. NAPSO admits and alleges that the Review Journal did nothing but receive information and publish it. So under the First Amendment merits analysis, even if they have standing, even if the statutory framework can be read to facially apply or be intended to have applied to the Review Journal, the First Amendment and the cases of Bartnicki, the Daily Mail Principle, Florida Star, Cox Broadcasting, over and again the Supreme Court has said when you've lawfully obtained information, you cannot apply such statutes to punish or prohibit or bar that type of speech. And again, the Nevada Supreme Court has made clear in the Review Journal case that even if you're not seeking damages, even if you're not trying to impose criminal liability, if what you're trying to do is seek injunctive relief, the same principle applies because, of course, contempt orders can issue when you have issues of injunctive relief and orders. There is an imposition of an obligation here. And the Nevada Supreme Court said there's no distinction in the type of relief that a movement seeks. So under those principles, the statute simply can't apply. I do want to mention, I didn't have a chance to think about the non-public forum concept. It was a new argument brought in today. It wasn't in the papers. Just to be clear, the First Amendment may allow some restrictions on time, place, and manner of speech that occurs in non-public forums like this courtroom. But the speech at issue in this case didn't happen in the courtroom. It didn't happen in the jail. It happened out in the public. It happened in the newspaper. It happened online. And so what applies there, the full-throated protections of the First Amendment that we talked about, including the prior restraint protections and including the merits-based analysis, that applies to whether the statute can apply itself. Excuse me, Your Honor. Right, and so one of the other arguments, and the city advances this, is that the Review Journal wouldn't have access to this information on its own. The city argues that the newspaper should have filed a public records request and it would have gotten a redacted image of footage from the jail. That may or may not be true, that the city might have turned that over. And that's what happened in the Conrad case, where the court applied this NRS 289.025 to say you can redact the images. But the First Amendment doesn't require the newspaper to rely on the government to provide information. There's other news gathering techniques that are lawful and that the Review Journal is entitled to rely on. Go and interview sources, receive information from out of the blue or from sources they know. Confidential sources, non-confidential sources, we're not required to rely on the good graces of the government to turn over information. That actually was explained clearly in the Daily Mail case. And so the concept that we couldn't obtain this information from the city, the unblurred photo from this images from the city, is irrelevant because we obtained them nonetheless. And that's Bartnicki. The fact that someone allegedly broke the law in getting that information and giving it to the newspaper doesn't change the analysis. It means that that statute can apply. And again, separately, the First Amendment ramifications of the prior restraint are considered completely separately. And whether the court focuses entirely on the prior restraint analysis, which it can do and we submit should do, or whether the court wants to look at the injunctive relief through the regular analysis, it still has to decide both the prior restraint issue and the injunctive relief analysis. And I'll close with a final point that NAPSO hasn't addressed. They are seeking a mandatory injunction as well. And that creates a higher standard than a regular preliminary injunction. Because to be clear, the videos have been posted and they will continue to be posted unless the court issues a prior restraint and unless the court makes us take them down. And that's affirmative conduct that the court would have to order us to take that would change the status quo. So all of these issues that we're talking about must be examined with a higher, through the lens of a higher burden that the law imposes on NAPSO, both as a mandatory injunctive relief issue and as a prior restraint issue. And with that, Your Honor, we submit that there's not a lawful basis for the preliminary relief that NAPSO is seeking today. The issues on the substantive merits are weighty and important, and we think we have the better of them. But if it's a close call today, Your Honor, then we brief that later in the rest of this case, but the court has to decide, is this going to be the first prior restraint to be upheld by the Nevada Supreme Court and the U.S. Supreme Court? And with that, Your Honor, I appreciate your time and consideration. Happy to answer any questions.
No, that's fine. Thank you.
Just a few points, Your Honor. I think we need to not lose sight of the plain language of the statute at issue here. NRS 289.025 subsection 1. Except as otherwise provided in subsections 2 and 3 and NRS 239.0115, the home address and any photograph of a peace officer in the possession of a law enforcement agency are not public information and are confidential. There's no limiting verbiage in there saying that it only applies to a law enforcement agency. Council just made a representation that they're not conceding that these officers may have not provided their consent or been arrested. I mean, I find that borderline preposterous. They're asking us to prove a negative. I mean, obviously, we can submit declarations from these officers that there was in fact no consent to release these photos, and researching whether an officer was arrested is not difficult. I mean, if that were the case, there would have been a separate article reporting on the officer's arrest.
That provision you just read a moment ago, the home address and any photograph of a police officer. There's the conjunctive "and" there, right? Which would be read to mean the home address accompanied by a photograph.
Respectfully, Your Honor, I would disagree with that interpretation, given that there's two separate subsections regarding exceptions, one applying to photographs, one applying to the home addresses. So I would represent that if it was to be considered conjunctively, the exceptions would have to apply to both the photographs and the home addresses. As to the representations made that there's never been a Nevada Supreme Court case, or I think it may have been any Supreme Court case holding that a situation such as this, preventing the press from reporting wouldn't constitute a prior restraint. I cited in my reply brief to Pona v. County of Ventura, which specifically states that prior restraints are not in of themselves unconstitutional per se. Again, the analysis has to include whether or not the underlying regulation is content neutral, which our statute clearly is. If preventing the relief requested here constituted a prior restraint and was prohibited, then why does the Review Journal have to comply with the Supreme Court rules regarding the electronic coverage of court proceedings and the Administrative Order 23-4 that I touched on earlier? If they have carte blanche and they can't be restrained from reporting, then they wouldn't have to request permission to record in a public forum such as a courthouse or images obtained from a jail, which is also a non-public forum. As to the case regarding the Nevada case regarding the autopsy results, the difference here is that there's no specific comparable statute protecting an autopsy as confidential information as there is here in regards to the home address or photographs of officers. There's a lot of arguments regarding, whether or not, as applied to the Review Journal, NRS 289.025 would be unconstitutional. The Review Journal is certainly free to challenge the constitutionality of the statute if it so chooses. However, that issue is not before this court. NAPSA would not be a party to such a challenge. All we're here today to decide is, was the statute violated in regards to these officers in this particular circumstance? And I think the plain reading of the statute in and of itself demonstrates that, and alternatively, the reading of the statute in the context of NRS Chapter 289 as a whole establishes that. Again, if the legislature wanted it to be limited to a law enforcement agency, that language, which appears in numerous statutes within 289, would appear in this particular statute. It would say, a law enforcement agency shall not publish or release the home address or photograph of a public officer. There's no language like that in the statute. Thank you.
Mr. Gochnour?
Yes, Your Honor. Just hopefully, and I won't say all the brief because we never are, but I'll try. Just regarding Mr. Cate's position, they love to cite the Pentagon Papers, they love to cite all the other cases. Those cases they're about prior restraint. They're about stopping the story from ever being published. They're also about stopping the use of the materials that are the story. These officers' faces are not the story. The story is not This officer's face, we are showing it because if it wasn't for this face, he wouldn't have gotten paid overtime and he wouldn't have made these mistakes. That's the difference that they're missing, Your Honor. This is not an infringement on the First Amendment rights. What it is an infringement on the statutory anonymity that these officers are entitled to. They talk about the fact that they try to turn consent on its head by saying, oh, they're required to come in and say, I never consented. No. Without proof of consent, you're not allowed to use these materials without redaction. That's the standard. That's their burden, not ours. Finally, Your Honor, I know you just made the argument about the conjunction in the statute. I think we can see that that's not necessarily the case.
I didn't make an argument, I just made.
I know, just to address that point so that we're clear, and I'm not sure that I've got the site right. I think it's the O'Callahan case that the Supreme Court decided where they were talking about body-worn camera video also being a photograph, and they were saying, in that case, it was produced redacted. It had nothing to do with the address. So in other words, the Supreme Court's already considered that we're talking about photos and videos, redaction of those without the conjunction of the production of address. So I just want to make sure that we address that point, Your Honor. And then, with that, Your Honor, I think I've said what I can say.
All right, thank you. All things considered and given the facts and circumstances present in the context of this case, I'm only addressing what's involved in this case, all right, that's performing. I'm not persuaded that injunctive relief is warranted, and accordingly, I'm going to deny the motion for preliminary injunction. I need to have a proposed order submitted by defense counsel setting forth preliminary findings of fact and conclusions of law, and an order denying the motion, and it will be, I believe, an appealable order. All right, and you can seek, if you are inclined to do so, you can seek further relief by way of appeal. Okay?
Thank you,
So,
Your Honor.
that's my ruling. Thank you.
Thank you.
Make sure you run the item by opposing counsel.
Thank you.
Thank you.
All rise.